Hi everyone, my name is Alexander Zalivako and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We will look in this presentation into the very specific and narrow aspect. On the one hand, how EU blocking sanctions are affected by the mechanism of investor-state dispute settlement and what the European Union is doing to oppose this mechanism being used to challenge its national sanctions program. But within this narrow topic, there is obviously a broader picture which we have here, meaning the ever-growing nature of the international economic sanctions, their relevance even for such long-standing and highly developed mechanisms for dispute resolution as ISDS. And we will structure our today's presentation by looking into the following 3 points. We will first of all make a short summary of the ISDS rationale and principles. We will then put into the context of this presentation the key issue of ISDS and sanctions, namely expropriation argument, and then we will consider specifically the recent attempts of the European Union to oppose ISDS threats to its national sanctions program. Starting with the ISDS as a dispute settlement mechanism may be summarized as a right of the investor typically granted under the bilateral treaty between 2 member states or several state parties to the treaty, like in the Energy Charter Treaty would be the example of the Multilateral Investment Treaty. So the right of the investor, which is not a party to the treaty, so the treaty itself is signed by member states, to sue the relevant member states in case of primarily the relevant investment is expropriated. The expropriation itself is a term which will be typically defined in the treaty in very broad terms, in essence, excluding the tax legislation. However, even that definition was even more broadly defined by the relevant arbitration tribunals, which are not bound in their guidance as to the national laws, which will define expropriation. And the main argument in the arbitration tribunals and the main point of controversy in terms of defining expropriation is the extent to which new laws adopted by the country and applying prima facie to all persons operating with that country can be defined as an expropriation in the circumstances when those laws reduce the expected profits generated by the investment. The examples where the claims were lodged before the arbitration tribunals in the circumstances are multiple these days and will include, for example, challenges being made about national pro-environmental legislation, anti-tobacco laws, national security laws, been challenged on the grounds that their imposition with respect to investment, even as I mentioned in the circumstances when those laws are of general application and not specifically target the relevant investor, as a result of imposing additional obligations and consequently reducing the revenues generated by the investment projects may be classified as an expropriation. And there is a ever-growing tendency of the arbitration tribunals to expand this notion, which originally was envisaged to encompass straight and simple circumstances when the relevant property is taken by the national authorities for their own purposes. Given the clear conflict between the investor and the state, the ISDS in principle functions on the premises that the national courts will not be objective when considering this type of disputes, that the national courts will be somehow inclined to favor the government which will be the defendant in this type of proceedings. And for that reason, universally, the jurisdiction to decide this type of disputes is vested into the arbitration tribunals, which are set by the parties for the purpose of a specific dispute. And the award of this tribunal is enforceable against the state and can be challenged in national courts only on very limited procedural grounds, like the fraud in tribunal, failure to notify the parties, certain public policy grounds, and other limited exceptions of this type of nature. They can't be reviewed in substance. And most importantly, they are enforceable not only within the territory of the states which are parties to the relevant investment treaty, but basically in most of the jurisdictions in the world due to the New York Convention. So what we can see here is a specific dispute resolution mechanism, which is in essence private in its arrangement and nature of operation, independent of national courts and the review of those national courts, and enforceable almost universally. And the logic for having this mechanism in place was, as I mentioned, the idea to give the investors objective, independent protection of their ownership rights with respect to the relevant investments made. It is quite clear in this narrative that the blocking sanctions, which almost universally prohibit all type of dealings with the asset, the person subject to the blocking sanctions cannot, in essence, do any kind of transaction, revenue generating transaction, disposal transaction, where the blocking sanctions are imposed, were challenged as an idea in national courts on the basis that those sanctions are either unlawful expropriation without compensation, because a person is deprived of his ownership and possession rights with respect to the asset for an indefinite period of time in a very restrictive measure, clearly in a much more restrictive measure than we compare these restrictions compared to, for example, environmental laws being imposed against the relevant investment project and in essence just reducing the revenues of the project. When the blocking sanctions are imposed, certainly no revenues can be collected or generated by the relevant asset, and no other rights can be exercised with respect to the asset unless specifically authorized by the national competent authorities. So here we face much more severe restrictions than in those cases where expropriation was found by arbitration tribunal, or in those jurisdictions where expropriation is not elevated to the level of constitutional protection, unlawful interference into the property rights, which in essence is the same argument that the property rights, although theoretically in place, is so substantially restricted that is becoming void of its purpose. So the argument then that the blocking sanctions are unconstitutional on one of those grounds, depending on a specific jurisdiction, have certainly been often made in national courts. And in the relevant proceedings, the arguments and counter-arguments which the parties relied are summarized on the slide. Quite clearly, the claimant was in essence making the point that the nature of restrictions imposed are so severe that they amount to expropriation, and this shall be considered in the context of blocking sanctions being typically of an indefinite duration. And then the counter argument of the state in these proceedings was in essence that legally the ownership right is in place, only the possession and transaction rights with the asset are restricted, that the deprivation or restrictions are not indefinite, but will come to an end at one moment of time, not clear at which, but they're not permanent. And then there are certain exemptions or derogations, procedures and mechanisms which are in place and which allow in certain, although very limited circumstances for a blocked person to use the blocked asset. In summary, in national courts, in these type of disputes, the view was taken that blocking sanctions are justified as a matter of national law and do not constitute either unlawful expropriation of the relevant asset or unlawful deprivation of property rights. It seems quite clear that if we put the same type of discourse and the same type of arguments in the context of a typical ISDS arbitration, where quite often the dispute relates, as I mentioned, to whether environmental laws, which require additional expenditures, been made in connection with restrictions in place, anti-smoking laws, which require, for example, specific labeling. So these type of restrictions are challenged on the basis of being expropriation. And the argument is in essence that they substantially decrease the profits, the revenues on investment, which can be generated. So if we compare these type of restrictions being challenged, sometimes successfully, with the blocking sanctions, it seems almost inevitable that an ISDS tribunal, which is seized with the argument that the blocking sanctions constitute an unlawful expropriation, which is supposed to be protected by the relevant investment treaty, will support the position of the investor making these arguments. And these type of arguments are now more and more frequently raised, specifically in the context of the blocking sanctions being imposed against substantial sectors of Russian economy. And one of the recent examples would be the case of Mikhail Friedman making a case against Luxembourg under the investment treaty between former Soviet Union and now Russia and Luxembourg, whereby he claims that a result of Luxembourg blocking his assets within its territory, given that he was designated a blocked person, he incurred a damage on his investment, and the claim is reported to be in the region of 15 billion euros, quite a substantial amount. Given this new development in the area, the European Union, which has traditionally favored ISDS as a means of dispute resolution with third-party jurisdictions, is changing its policy and has been taking quite unprecedented steps in terms of preventing this type of proceedings to the extent they result in the award from being enforceable. And the European Union is doing it in two ways. The first way is to prohibit the enforcement of those awards within the territory of the European Union altogether, and prohibiting any kind of assistance being provided in connection with this type of arbitration proceedings. But more interestingly than that is a special mechanism which in essence obliges a state, to the extent an award is granted against such a state within the relevant ISDS arbitration, to seek compensation from the relevant investor within the territory of the European Union. And if we think about this idea for a while, then in essence what this means is that the European Union created a mechanism which would allow member states, in essence, to seize the blocked assets within the territory of the European Union, currently formally owned by the relevant investors subject to the block sanctions, for compensation purposes. In essence, creating a circle whereby the relevant investor may seek enforcement against the assets of the member state outside of the EU jurisdiction, for example, in the United States, seize those assets, compensated claim for the amount of those assets, and then the EU member states will most likely attach the already blocked assets for compensation purposes. This by itself is quite an unprecedented step, which, thinking about this, logically frustrates the whole purpose of the blocked assets mechanism, because the assets would in general be deblocked and we will be available for the member states themselves in this type of compensatory claims. Thank you very much for watching. I trust that you found this presentation useful, and I hope to see you during my next video presentations.